Here we go. All right, here we go. Thank you so much for joining me today. And we are here today because you were invited by somebody who cared enough to invite you to this seminar, webinar, because education is so important. And thank you to the person who invited you to learn a little bit more about an estate plan and living trust and why they're important and all that stuff. It's the hot topic these days, it seems. So I'm here to help educate you, my favorite thing to do, and my name is Michelle Reese Johnson with AmeriEstate Legal Plan. 27 years in business, actually going on 28 now. We've been serving families to get their estate plan set up and educating and pushing it and seminars and webinars and in-person meetings and whatever it takes to get people to understand why it's important, because this is definitely something you want to do before it's too late. And you want to do it while you're feeling good, and you put your plan in place, and then it's there for your life. So in this group that I'm chatting with today, how many of you have anything in place? Just give me maybe a quick little thumbs up or something. Do you have any type of power of attorney for health or finance, a healthcare directive, a will, or just a living trust? Yes, we are going to be giving copies of the presentation out. So, okay. Richard has something. Petra doesn't have. Oh, sorry, I'm not going to call out anybody. So, I see a few people telling me what they have. So, I would say that most people don't have anything. That's pretty much the standard. So, this is just some basic things that all of us who are adults should have at least something like this in place. So let's talk about what an estate plan is. Well, estate plan isn't just I'm not going to just say an estate plan is a living trust. No. An estate plan determines many different things, and not everybody needs a living trust. But an estate plan is a document that you have put in writing, and it can be either just powers of attorney. It can be just a will. It can be a living trust. But an estate plan is basically a plan that you put in place legally that if something should happen to you, there is a plan in place that you can tell either the courts or your successor trustees and beneficiaries who are going to get your items and how you want things distributed, and it's going to avoid lengthy probate processes. It's going to make sure that when you're alive, your financial and medical decisions are handled. That's through your powers of attorney. It's going to make sure that if you have any minors or special needs children, they're going to be taken care of should you become incapacitated or pass away. And it's just going to minimize any conflicts and make sure that your wishes are carried out. So that's basically what an estate plan is. And let's talk about who needs an estate plan or a living trust. Now, not everybody needs a living trust, but if you have any of these types of assets or situations, you will definitely be one of those people or families that need to consider setting up a revocable living trust. Now, here's the list. You need a living trust or should think about getting one if you are a homeowner, a business owner, parents of minor children or special needs dependents. They could be adult special needs or minors. Single people that have assets and minor children. Every state has a different probatable asset, but for instance, in California, if you pass away with assets that are over $204,000, that's bank accounts, cars, things like that, that will be a probatable trigger that will have to go through a probate in a court process. And if you have real estate, that's the number one thing that's going to go through probate. If you have investment property, land, you could have stocks, bonds, CDs. Okay, all of these things will go through a probate process if you do not have a plan in place to take care of those items when you pass away. So I've been doing some will portfolios for people lately because frankly, they don't really need to get a living trust. And I'm going to share with you what that looks like. Why they might just need a will and why not a trust. So I will go over that with you because people get very confused. So let's talk about the common ways to set up an estate plan. Okay, so the first way is the do nothing way. We all know what that is. We just haven't done anything. We don't have any powers of attorney in place. We don't have a will. We don't have a living trust. We just have nothing. And you know what? It's not illegal not to have a plan in place. I would say 80% of people don't have anything in place. Adults, they have nothing at all in place. So that is the most common estate plan, is the do nothing plan. The next most common estate plan is just a will. A lot of people, they see these free things like, oh, if I sign up for this, I get a free will, and think, okay, I've done my duty as an adult, and I put my will in place, and I've said who I want my beneficiaries to be and who my executor of my will is going to be, and I'm good. Yay for me. Okay, so, and the other most common thing we see a lot of is people putting others on title with them. Mostly we see parents putting their children on title to their assets with them. We see a lot of possibly a married couple and one of the spouses has died and they're taking title as a joint tenant or a community property, and the husband passes. I like to pick on the husbands first. He passes, and then the mom or the wife is left, oh my gosh, something just my husband just died. What if something happens to me? I better throw my son on title with me. I need to put him on the house, because if something happens to me, at least he gets the house, and he's going to share that house with his sisters and brothers, right? I should also put him on my bank accounts, because I know that if I'm alive, he can get access to those bank accounts and pay my bills, right? So a lot of us think that way. So that's called the Band-Aid approach, just putting people on title with you. Okay, we're going to talk about why that's not such a good idea. The best and most popular, or not most popular, but we're trying to make it the most popular thing to do, is setting up a living trust if you have those types of assets, minor kids, special needs kids that we talked about in the previous slide. A revocable living trust is going to avoid probate, going through the courts, the attorneys, the time frame it takes to get through that. It's also going to be something that will handle things for you while you are alive as well, because there's the living trust, and within our portfolio, you also get your powers of attorney for health and finance. Now, those two documents are only good while you're alive, but they are so important to have, because if you become incapacitated, you can't pay your bills, others cannot talk to any financial advisors, tax people, IRS, whoever it is, the water company cannot talk to anybody on your behalf without a power of attorney for finance. And the doctors and hospitals cannot talk to anybody without a health care directive. So with our portfolio, you're going to avoid all of this because you're going to have a revocable living trust, a pour over will, your healthcare directive, and your financial power of attorney. So it's going to avoid conservatorship altogether. We see clients that call us when mom's had a stroke and they need to get access to her bank accounts and pay her bills. And mom does not have her power of attorney in place. So guess what happens? They have to go get an attorney to represent mom and do a conservatorship over her because she did not put these documents in place. So you want to avoid this altogether. This living, I call it a living probate, and when you pass away, when you're deceased, that is the regular probate. So probate takes a long time. The courts are very, very backed up right now, guys. And so in order to even get your estate to the court system, it takes about 6 months. And then from there, it's another year. So you're looking 1.5 to 3 years or 2 years to settle an estate. Your assets are frozen. You cannot access bank accounts on behalf of your deceased parent. You cannot, well, you might be able to sell the house, but the courts have to approve it. But any money from the sale of that house has to be stuck in a bank account where there's an appointed person by the courts that have to oversee that. It costs a lot of money. The next slide I'm going to show you is how much it really costs to get this estate through probate. And if you pass away without having a living trust, the courts have a plan for you, meaning the state that you live in has a specific plan on how your assets are going to be distributed. It's not what you would have wanted. It's what the state has decided, because most people don't set these up. And so the states have to have this kind of default plan that just happens when you don't have anything in place. You also, if you have minor children, you need to make sure that you have set up guardians who you would want your children to go to before something happens to you, before you become incapacitated, before you pass away, because the courts will also decide where those children go. And I see a lot that people come, like family members will come out of the woodwork and say, well, I'm the aunt. I'm her aunt or that child's aunt, and I want them to come live with me. And you might go, no way in heck would I want that person to be in charge of my children. So be very, very careful and be assertive and make sure you get guardians in place for your minor children. And also with going through probate, it becomes public knowledge. With a living trust, it's a private plan. So when you go through probate, you got to let all the creditors know. Everybody can get into your business. They can find out what assets you have. They can show up to court, and it can be a 3-ring circus. So keep your affairs private and get a living trust if you pretty much qualify for one. Definitely consider that. So here's a little bit of the cost on a living trust. Look at this. Okay, let's say $500,000, and let's say your house is everything together, including your property and your financial accounts. If you do not have those things in a living trust, or you do not have a beneficiary on those bank accounts, it's going to be based on the gross value of your estate. Okay, not the net, not the loan less what you owe on it, not that net. The gross value of your house plus everything else will be about 6% off the top once everything's settled. That's how the courts and the attorneys and all the people who do all the paperwork and the filings get paid. So $30,000 is going to come right off the top before anybody else or your heirs get any money, and it might not be who you want to get it. So this calculator here, it also talks, it gives you a little more in-depth detail. Like if you look at this one, we've got a $700,000 house, a $250,000 in savings and investments and vehicles and household property, and you add all it up, right? So this is probably what a lot of us have right now because houses are so expensive. So you're looking at about almost $100,000 is going to go right off the top. That's just going to go there to pay the government employees and the attorneys and all that. Probate's big money. So they like probate, the attorneys love to do probate because they make good money. So keep your affairs out of all that mess, and a living trust is probably the best way for most of us to set that up. So let's compare. Probate can be expensive, time-consuming, traumatic, and public. Living trusts, it will avoid probate altogether as long as you have a death certificate. You can get access to the assets, sell the property, pay the bills, control the situation. That's it. Probably the longest thing most people have to wait for is a death certificate. So once you have a death certificate, you can walk into the bank if you're the successor trustee, give them your ID, copy of the trust showing you are the successor trustee, and they will give you immediate access and put you right onto that bank account. Now, you are not the owner of it. You are just the trustee of that bank account now. You are the manager of that bank account. You have some duties and responsibilities, but shoot, you can step right in and pay the gardener, keep the lights on in the house, make sure that whoever's living in there isn't going to be kicked out. All those things come into play when you avoid probate. So it's not just about the money, it's about the hassle and the personal things that go on behind the scenes. So you want to make sure that, you know, if you do a living trust, you'll know all these things are going to happen. It's going to be private. Nobody's going to get in your business. You might have a little, you know, brother sister stuff going on or sibling stuff where people don't agree with what mom and dad said, but you're in charge. The successor trustees is in charge, and they have the instructions. Sorry, this is what mom and dad said. This is what I'm going to do, and you can settle that estate pretty quickly. Okay. So let's talk about what an asset is. All right, we're all here, living our lives, having our children, buying stuff, getting our house, maybe want some investment properties. Maybe we've inherited something from our parents. Maybe we have some toys. We could have boats and planes and all kinds of stuff, right? So these are all assets, okay? And our most precious asset, in my opinion, is our children. So we want to make sure that all of these assets stay out of that court system and go directly to who you want to quickly without the expense of probate and without the time and the hassle of going through it. So when you set up a revocable living trust, at least AmeriEstate's living trusts, it's a complete estate plan package. It actually looks like this, okay? This is what everybody gets, but inside is customized to you on exactly what your plan is, who you want to be in charge of it, who's going to take care of your children. Maybe you're going to give, your plan is going to be, well, I kind of want to hold the money out, hold the money until my kid gets through college, and I'm going to give him maybe a third of everything at 25, but I want to hold it back until 30 because I know how I was at 25. I probably wouldn't have been a good steward of my millions of dollars I'm inheriting. So that's why you're going to choose a successor trustee that you trust to fulfill your wishes in your trust for your children, and to make sure that they become stewards of the assets they're going to inherit from you. So with a living trust, you can do these things. With a will, you cannot. You cannot put instructions in a will of at what age they're going to get it, at what's, and if there's special needs children, they just get the money. If you put your children on as a beneficiary to an asset, they get it at 18. There's no way to put an age limit on that. So you want to make sure that you have a plan in place that will go for your future, for your, as your children grow. Maybe they're minors right now, and maybe you pass away. Well, in your trust, it's going to tell that successor trustee what you would want, meaning that they're going to hold that money in trust for health, education, welfare, and well-being for that minor child. Like they'll pay for their education, they'll pay for their food, clothes, give money to the guardian to help take care of them, whatever it is. But you don't want them to turn 18 and all of a sudden get a bunch of money, right? Well, that's what happens when people put their children on as a beneficiary directly on bank accounts or life insurance and things like that. So you want to be very careful on how you do those things. And I would say give us a call so we can help guide you and decide maybe a living trust would be the best decision for you, or maybe a will portfolio would work best for you because of maybe your children are adults now and maybe you don't have real estate anymore, and all these kinds of other factors come into place. So give us a call so we can talk to you before you decide that you need maybe just a will, or maybe you don't need anything. So in our living trust, this next slide here, they include your healthcare directives, which is your POA, power of attorney for health, your power of attorney for financial affairs, a pour over will. Every trust should have a pour over will. And you can see it's spelled POUR because what happens is sometimes people forget to title assets into their trust name, and they pass away, and that asset might still go through a probate, but the will catch it and throw it into the trust and distribute it according to the terms of the trust. So you need to have this pour over will with a living trust. Well, with your living trust. Also, when it comes to funding, we fund all your assets, meaning your real estate. We make sure that it goes out of your name as a single person or a married couple as a joint tenant, and that gets quitclaimed or granted into your revocable living trust. That's how you protect that property. That's how you protect those bank accounts. Same thing with your bank accounts. It's called funding. So we're going to help you understand how to fund your bank accounts, and we're going to take care of those properties that are just sitting around in your name and make sure that that gets protected by putting that or retitling that into your living trust. We also provide you with an attorney consultation over the phone. So we do not do it yourself here, guys. We do it with an attorney who you speak to, and the attorney guides you and makes his recommendation of the best plan for you, okay? Don't get fooled by the do-it-yourself. That's non-attorney guided, and there are a lot of disclosures in those things saying you are deciding all this on your own. This is a self-help situation. If you want to talk to an attorney, go seek attorney advice. We are not giving you any advice. You are on your own. If anything happens, we're not liable, is what they're saying. So don't go that route. Get expert help. AmeriEstate is that help for you. And also, when it comes to getting your trust signed, it's very important you know what you're doing, and that's why we deploy notaries to come to your house to see you, to get them all signed and in place properly, notarized, witnessed, guided, signed. So that is a very, very huge step when your trust is ready, to have experts who know exactly how to put that in place so it's a legal document should things happen. Also with AmeriEstate, we are AmeriEstate Legal Plan. That's our name. So with that, when you do any kind of estate planning with us, you have joined the legal plan, which gives you access to a lot of other benefits like changes and amendments to your trust, access to attorneys for any matter that might come up in your life for a free consultation, and a 25% discount off their hourly rate. We also have other services included in that legal plan membership, that like a DocuBank wallet card, which houses your healthcare directive electronically as well. So there's other things in the legal plan. We can send you some information on that if you want to know more, but that's all included in the price. So, and I skipped over that. So actually, here's what I was just talking about. And then I just want to say, is it true or false? Does AmeriEstate cost 30 to 40% less than other attorneys? Well, I think we all know what I'm going to say, right? Absolutely. AmeriEstate is that perfect sweet spot for clients who are looking to have access to an attorney for their legal consultation and the support to set up the right estate plan for them. There are a lot of different kinds of estate plans out there, people, especially for married couples, that you want to make sure you are in the right kind of estate plan or living trust, because married couples have very dynamic situations, children from prior marriages, houses they've inherited, whatever it is, it can be very complex. So don't just leave it up to a do-it-yourself. Let AmeriEstate help you. Most attorneys charge $300 to $6,500. I've seen a lot at $10,000. Seriously, it's shocking, absolutely shocking. But you know what? The attorneys must charge this kind of money because they're doing a lot of upfront work, one-on-one with you, back and forth, signing, they have a whole team of people they need to pay, and they charge $500 to $600 an hour. So that's why it's up there in price, because it's usually on an hourly basis. With AmeriEstate, we take all that busy work away from the attorneys. It's kind of like being a nurse, where the nurse is that person that gets in and gets all that information and helps you understand what's going on, and then gathers all the facts and then gets that over to the attorney. So he focuses on the estate planning aspect for you and the legal advice for you. So we work as a team, and that way we can bring those prices or those costs down to our clients and end users, so they know that they are getting a good quality estate plan that's backed by an attorney, spoken to by an attorney, and amendments and changes are done significantly cheaper or free over the years. And AmeriEstate will be here for you for the life of your trust. So let's talk about what AmeriEstate charges. And we have a great special till the end of the month, guys, because it's Halloween, right? Our estate plans are $1,895 for a single person or $1,995 for a married couple. And then we have deed processing fees, which are, we have to retitle that house into the trust. So those are $250. And then there's a recording fee of about $60 or so, depending on the state and the county where your real estate is. We can do any state pretty much in America. There's a few that we can't do, but we can do property all over. So just know, whatever state you're in, and if you have property in different states than AmeriEstate's in, which is California, Arizona, Texas, Tennessee, Virginia, and Maryland. If you have property in other states, we can also do those, and we can record them for you. So just know we can handle those and get those into your trust. Knowing just what I said about the pricing, we have a special offer. Okay, so reach out to us if this is something you'd like to get started by October 31st. You're going to get $100 off your living trust, which is a really awesome incentive. So talk to the person who invited you here, or just give us a call so we can help you get started, or at least get you educated a little more on your situation and take advantage of that $100 before by October 31st. Okay, you don't have to start it, but you just have to commit to it and pay for it, and then we can work on your plan after that. A little bit more about what AmeriEstate does. It's just not about doing a living trust, even though the irrevocable living trust is our core foundation. It's everybody's core foundation. And I'm going to get to some questions after this. So the living trust is how AmeriEstate started, and then as our clients have aged and families have grown and people have passed and become incapacitated, our other departments have been up and running for many, many years. But usually the next thing is our trust administration. Maybe somebody's become incapacitated and we need to step up somebody to start taking over for mom and dad's affairs now. I did that with my parents. I stepped up to be a trustee with them. So we're all together, which is very helpful because I can walk into the banks and talk to them and they won't shoo me away because I'm a trustee with them on their bank account. So we're going to help you with those things. We're going to also help your successor trustee and your children. When you pass away, we're going to be their coach, guide them on what they need to do, help them understand the process. And there will be fees for that, but it's very reasonable based on what we're doing. Sometimes it's just transferring a house into their name. Sometimes we need to do probate letters for certain states. Beneficiaries need to see copies of the trust. There's certain things that need to be done, but it's not a lot and it's very manageable for them. And they love having a place that they can call and not get billed $500-$600 an hour, right? Another thing our clients like to do is set up corporations or LLCs. Think LLCs are a pretty good way to protect your your properties and things like that. If you have rentals and all that, it takes that property out of your personal estate by putting a bubble around it. So let us know if you need any LLCs or corporations done. And again, and then one of our parents becomes incapacitated and can no longer handle their affairs, as long as I know for sure if they have an AmeriEstate Living Trust and an AmeriEstate Power of Attorney, we can do incapacity planning by doing some documents, a couple doctor's letters saying they're incapacitated, and step up those trustees, and you can start taking over while your parents or the person who put you in charge is incapacitated. So if you guys, anybody here would like to get started or talk about your situation, have a free consultation, and get that $100 off your trust, here is the phone numbers to call, or you can always visit our website right here, and just let them know you were on the Living Trust seminar and you'd like to take advantage of that offer. And just make sure you do it before the 31st of October, okay? Let's see. I want to go through some questions. Okay, Ryan said it might be helpful to let us know which states you cannot operate. Okay, how about the states I can? I think I went through it. California, Arizona, Texas, Tennessee, Virginia, and Maryland. Those are our 6 primary states. So if you have people that live in those states, or you're going to move to one of those states, we can do your estate plan for you. It doesn't matter where you live in the state, we can do it, because our attorneys will be talking to you over the phone, and the notaries we deploy will be coming to see you, okay? If you're local to our corporate headquarters, which is in Costa Mesa, California, you're welcome to come in and see us. No, we're there all the time. So let's see, what else? We are going to be sending this presentation, this replay to you. If you registered, you will get the replay. If you want a copy of the presentation, absolutely, we can email this to you if you like. And also, I can also send you some other videos if you would like a little more education on I do different types of videos, but this is the basic one that most people need to know why they need a living trust, or maybe they don't. It just depends on what you have, what assets you have, how old your children are, if you have minor children, if you have special needs children, if you just have retirement funds and all your kids are grown, that might just be a will portfolio. But talk to us first and we'll kind of help guide you. And then the attorney will do the final deciding with you on a trust or a will. You need at least something, okay? So get at least your powers of attorney done if you don't want to jump into a trust. But the living trust has everything in it. It's the full package. It's the creme de la creme of estate planning for most middle Americans. So, and AmeriEstate has it all nicely put together and easy to follow for you. Let's see here. Anybody else have questions? Because I'm here and available to answer them for you. And if not, feel free to just reach out and email me. I think you might have my email from the webinar link. And let's see, right now it's about 38 minutes into this. So I'm going to call it a morning. And it is top of the morning. And now I got to go pick up my dad from the hospital, and his surgery was successful. So thank you so much for joining me today. And I appreciate you all just listening and getting educated. That is the key, is education. And I love helping people understand why this is so important and all the little ins and outs. I can talk for days on stories of things that happened when people did not have documents in place. And so I'm just a big advocate. So you're welcome, Damsha, for the information, and you're welcome, Amanda. And thank you all for your time today and being here and being present and listening to me babble on. Okay, everybody, have a great rest of your day, and thanks again. Bye-bye.